Welcome to our YouTube video series on business law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we'll be discussing the differences between a regular arbitration and an expedited arbitration. Now, an arbitration is a means to resolve a dispute without the parties needing to go to court and having a judge make the determination. And it is a binding resolution as opposed to a mediation process, which typically is not binding. And as such, the intention of arbitration was to facilitate the process similar to the court system, but with greater speed and greater focus and efficiency. Unfortunately, because lawyers are so heavily involved and lawyers are pressing a lot of stuff, regular arbitration became bloated and slowed the process down such that it is not a speedy process oftentimes. And hence the creation of expedited arbitration procedures. So let's look at what the difference is between these two. So an expedited arbitration, which we will focus on first, is set at a fixed fee. There is a set amount of time, very strict time frames, limits on the documentations, the length of briefs, and the time for the hearing. So as you see, very, very restrictive. And the arbitrator who's overseeing it really has no discretion to exceed those time limits or page requirements, with the exception of there being exceptional circumstances or on consent of all the parties involved in the arbitration. And as such, many of these expedited arbitrations take place in a period of less than 90 days. That means from the start where the arbitrator is named through to the arbitrator's rendering their final written decision. It can be done typically within a 3-month period, and that is dependent upon the structure of the prevailing rules. And the hearing itself is often limited to a single day. Naturally, the parties can consent to a bit more time, but that is what the structure is. And as such, it produces a very fast and inexpensive means to achieve a resolution to a dispute, which in the business context can be very important. Conversely, a regular arbitration process is far more drawn out because it starts off with an agreement to arbitrate, but the parties still need to oftentimes set the specific rules and procedures upon which they are going to arbitrate the matter. And most often, where a party has a weaker position, they want to spend more than enough time trying to challenge stuff and not admitting as to where their position is. So they're going to want to press on things, try to bring up things, try to influence the arbitrator, and expand out the process. And the parties are going to want to try to bring in as much as possible. And this is also their lawyers, because the lawyers are often cautious about losing cases. So at the minimum, they want to try to say they did everything possible in an effort to either win the case or to mitigate the losses that their client incurs. And to effectuate that, they try to expand out the arbitration. And this creates of itself an expansion of time and expansion of cost, because now the parties are spending more time, not only with lawyers' costs, expert costs, and the like, preparing more extensive materials, longer hearings, but it is also adversely impacting their business. And as such, the value of expedited arbitration in most circumstances is very apparent. And as such, where the process does not require this expansive approach and analysis, it is beneficial to have expedited arbitration clauses put in and to pursue expedited arbitration procedures, such as the matter might be resolved in a very short time frame, relatively speaking, especially from a court and general arbitration outlook, and that the business might deal with the situation and then move forward. As such, focus should be on understanding the value of expedited arbitrations and seeing as to whether they should be included in many of your agreements and in many of your dispute resolution scenarios. Thank you.